What happens if an attorney fails to live up to his promise that he makes to the jury at the very beginning of your case? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now let's say you brought a lawsuit against your doctor claiming that he was careless and that he violated the basic standards of medical care, causing you significant harm and injury. The doctor goes ahead and disputes your claim. He says, I did nothing wrong. Why are you suing me? I don't understand this. And by the way, if I did something wrong, so did you. And then he says, you know what? If I did something wrong, whatever I did didn't cause or contribute to your injuries. And then he says, he has the nerve to say, hey, if I did something wrong and I caused you harm, your injuries really are not that bad. Those are the typical defenses that we see. So they usually will say at that point, listen, we'll see you at trial. We're not negotiating this case. We're never going to settle this case. We'll see you at trial, which means 2 or 3 years down the road. That's the length of time it takes to get to trial here in New York. All right, so now you finally get to trial. The jury has been selected. The judge welcomes the jury. And now it is time for your attorney to make opening arguments. The judge turns to your lawyer and says, Counselor, you may begin opening arguments. And now your lawyer stands up and begins to tell the jury a story. And now during the course of his opening argument, he makes certain promises to the jury. And some of those promises include, ladies and gentlemen, you will learn during the course of this trial that Dr. Jones violated the basic standards of medical care. You are going to hear from medical experts that this doctor failed to do A, B, and C. We're going to show you that we are more likely right than wrong, that this doctor did not do what he was supposed to do, and because of that, this patient who comes to you today suffered significant harm and injury. We're going to show that to you. Now, at the very end of the trial, each attorney has an opportunity to make closing arguments. The defense lawyer goes first, and then your attorney, the patient's attorney, goes last. They have the last word. Actually, you know what? That's not true. The judge is the one who has the last word. After the attorneys give their closing remarks, the judge then gives legal instructions to the jury. So what happens if your attorney fails to live up to the promises that he made during opening arguments? You know what's going to happen? The opponent, the opposing lawyer, is going to highlight the fact that your lawyer has promised certain things or had promised certain things at the beginning of the case, and he promised to show you testimony, he promised to show you evidence that would go ahead and prove those things. And now at the very end of the case, he turns to the jury during closing argument and says, ladies and gentlemen, Mr. Oginski promised that he would show you the following things. He brought in various witnesses. He showed you various evidence. You heard testimony from all these different people. Where is the proof? Where is the evidence that he did X, Y, and Z, or that he failed to do A, B, and C? If I'm unable to show or to live up to the promise that I made at the very beginning of the trial, you know what happens then? My credibility is going to get destroyed. The defense lawyer is sure to point out to the jury that I failed to live up to my promise, the promise that I made to the jury. And how does that affect me? How does that affect my client? I'll tell you how. It can significantly affect the case. It can highlight and show to the jury, hey, we don't have a claim here, or our claim is very weak. Why? Because all of the testimony, all of the evidence has failed to prove, failed to show exactly what I claimed it would show at the very beginning of the case. So that's a very important reason why attorneys will request daily transcripts, especially of the opening remarks and also of closing remarks. And why is that? The daily transcript is actually the court stenographer recording every single word that is spoken in the courtroom. And now when we purchase from the court stenographer the daily transcript, it happens to be expensive, but when we purchase that and make that investment, we now have the actual words that are said by our opponents, by us, as to what exactly it was that we promised, as to what we claimed we were going to show, and can look at all the testimony and all the evidence that we presented, and now determine whether or not we have in fact proven what we claimed we would, that we've shown them and promised them at the very beginning of this case. So now I can feel confident and stand up in front of the jury during closing argument and say, ladies and gentlemen, at the very beginning of this case, I made you a promise. I promised that we would show you that we were more likely right than wrong, that this doctor violated the basic standards of medical care. Well, let me show you how. Let me remind you about the witnesses that we brought in. And here's the evidence that was used to explain why this doctor violated the standard of care. And now I could say, look, at page 375, the doctor said the following thing. And guess what? Another expert came in a little bit later on, and at page 627, he said the following thing. And what am I doing? I'm highlighting to the jury the fact that I have lived up to my promise. And now if I can show the jury at the very end of the case, listen, here's what I promised you, here's the evidence that supports these promises. So yes, in fact, I have lived up to my promises. But if I haven't, now my opponent is going to use that against me and against my client to show that we don't have a valid and meritorious case. So it is extremely important that if and when an attorney does make a promise during opening arguments in your trial, that he live up to those promises at the very end of the case. And the only way to do that is if you have the evidence and testimony during the course of trial to support those promises. So now at the very end of the case, you can turn to the jury and say, ladies and gentlemen, I made the following promises to you, and take a look. I did in fact live up to those promises. And here's how, and here's why. So why do I share this great information with you? I share it with you just to give you an insight of exactly what happens in these medical malpractice trials here in New York. You know, I do understand you're watching this video because you likely have questions or concerns about what happened to you. Well, guess what? If your matter did in fact happen here in New York, and you have not yet started a lawsuit, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.